Honor, this is Mr. Valentine, whose matters I believe are at the end of the calendar, numbers 26, 27, and he has declined counsel and would like to proceed on his own. I believe
So
my office had been this matter before.
Yeah, Mr. Valentine, you had an attorney appointed and then you didn't come back the way we needed to come back way back in March. So you got an attorney sitting there, an experienced criminal defense attorney, might help you. Would you like to take the advantage of having Thurston County Public Defense represent you again?
No, ma'am.
Can you tell me why?
Because I would like to proceed sui juris, because I believe I have my best interests, and I don't think anyone else in this court has my best interests.
This case right here is the perfect storm of confidence, conspiracy thinking, and straight-up courtroom chaos. Mr. Valentine is part of that growing group of sovereign citizens who believe that if they just say the right combination of magic legal words, the entire justice system will suddenly pack up and leave them alone. But here's the twist. This isn't just traffic tickets or minor citations anymore. We're talking multiple DUIs, failure to appear, warrants stacking up, and a judge who is clearly running out of patience. What makes this even more wild is that Valentine isn't just refusing an attorney. He's determined to outlawyer actual lawyers using phrases he found on the internet. Throughout this hearing, you're going to see him question the court's jurisdiction, deny being a legal person, and even try to implement rules that he has absolutely no power to enforce. And the judge? She's calm, professional, and slowly getting pushed to the edge by the non-stop pseudo-legal word salad being thrown.
Okay. All right, well, first, there are a couple of warrants. I'm going to turn to the prosecuting attorney, Mr. Abid, first, and see what their recommendation is on this warrant return, and then I'll turn to you. So I'll just allow you to represent yourself today as you want to. Mr. Abid?
Your Honor, the state would object to releasing Mr. Valentine, and the alternative the state asked that the court set substantial bail on both of these matters. The first one, ending in the cause number 693, is a case, is an old case. Mr. Valentine, I'm seeing, has substantial failure to appear history. This is here's sorry, Your Honor. Mr. Valentine was on warrant status for a significant period of time. In March, the court issued a $15,000 warrant on each case. The court, Your Honor, or the state, Your Honor, asks that the court impose bail in the same amount as the warrants.
And this is first DUI from November of 2021, and then the second allegation, January of 2024.
Correct. And
were these, one, it appears, was an allegation of a breath sample of 0.14, and the other from 2024, do you know the allegation?
My notes show that 2024 allegation was included a refusal.
Okay. All right. So, Mr. Valentine, what the state's asking me to do is have you post about $30,000 cash or a bond bail, and consider those same restrictions that were on you before, that you show up at pretrial services, that you stay clean and sober, you stay law-abiding, you give UAs, you be on a device that's attached to your person to make sure you're not consuming alcohol. What do you have to say?
I object to that, Your Honor. I did make my best effort to show up at court, even when I didn't show up because I was confused about the dates. The clerk told me the wrong date. I showed up. I gave the clerk a letter. I wrote a letter to the court, and I also wrote counterclaims and responses to the State Attorney General's office, and I got no response from either. I went to try to squash the warrant. They told me that they wouldn't squash the warrant. They wanted me to either turn myself in, or they wanted to get me to pay more bonds. I have absolutely no problem showing up and representing myself. As far as What was the next thing? As far as these charges that are against me, I wanted to be clear that I am not a person. I'm not a legal entity. I'm a living man, and I want to enforce my constitutional rights. I have the right to. If not, I do not wish to contract with any members of this court.
The most dangerous illusions that sovereign citizens fall into, the idea that passion can replace training. Court isn't YouTube. It isn't a comment section. This is a place where procedure matters even more than emotion. A defense attorney doesn't just talk for you. They know deadlines, motions, evidentiary rules, sentencing ranges, and exactly how badly you can sink your own case just by saying one wrong sentence on the record. When defendants represent themselves, they think they're controlling the narrative. In reality, they are walking through a legal minefield blindfolded while dancing. And notice the judge here. She's not being sarcastic, not mocking, not dramatic. She is practically begging him to reconsider counsel because she knows exactly what's waiting for him in a jury trial. The court doesn't benefit from him crashing and burning. The system actually runs smoother when defendants have lawyers. But sovereign citizen ideology always frames help as control. So instead of accepting professional guidance, he interprets it as a threat and walks deeper into trouble with complete confidence.
And it is also my understanding that this is a Nisi Prius court, and I would like to implement Rule Nisi.
Well, Mr. Valentine, I'm going to hold you on $15,000 cash or bond bail on each of these independently. So you'd have to post bond to be released, as I find that you're a risk to reoffend and a risk to commit, another DUI or vehicular assault or homicide, given the history while under the influence. So you're a danger to the community is what I'm finding. And you don't come back when we order you to come back, and you don't comply with court orders. So 15,000 cash or bond has to be posted on each one of these separately. And then you have to get yourself into pretrial services within 48 hours of release and have a scram device attached, stay clean and sober, stay law abiding, in order to stay out of custody. No alcohol, no marijuana, no non-prescribed drugs, no bars or taverns, and don't drive unless you have a good license and proof of insurance. I'm going to set another court date. We would do this.
What jurisdiction is this court operating under, Your Honor?
Thurston County District Court here in the state of Washington.
Well, what jurisdiction are you trialing me under?
What jurisdiction? Thurston County District Court, Thurston County, state of Washington.
That's not what, is this under a common law jurisdiction?
I'll have you research all that yourself, sir. I'm not going to argue with you. I have jurisdiction over you and over this matter.
So is this court operating common law, ma'am?
I'm talking to my clerk. 1 second. And make it clear, good, that he's proceeding pro se and that we need to do.
I am not pro se. I'm seri juris.
All right. You're proceeding without an attorney.
Did you take an oath to uphold the Constitution of the United States, ma'am? The supreme law of the
I
land?
sure did. I take it every time I get reelected, and I take it very seriously.
Will you be honoring that?
Very seriously.
Are you going to be honoring that
No,
oath
it's
today,
just
ma'am?
free trial, and then we'll get it set for confirmation and jury dates.
Are you honoring that oath today, ma'am?
I sure am. And I do it every day.
So you think I'm a person?
I sure do.
So you think I can be bought and sold and regulated? You think I'm a persona, that I live in the likeness of another?
This is one of the classic sovereign citizen talking points. The idea that laws only apply if you consent or contract with the government. Unfortunately for that theory, criminal law does not operate like a gym membership. You don't get to opt out of DUI statutes by declaring yourself a free-range spiritual entity traveling the land. The social contract in criminal law isn't signed on paper. It exists because you use public roads, public infrastructure, and endangered public safety. Courts don't need you to raise your hand and say, I agree. They only need evidence and jurisdiction. What's happening here is important. Is confusing civil contract law with criminal prosecution. In civil disputes, Contracts matter. In criminal cases, the focus is conduct. In this case, alleged impaired driving, refusal, and failing to appear. So when he demands a contract, the courtroom doesn't pause in shock. They just keep going because the demand itself is legally meaningless. His jargon sounds powerful online. It has exactly zero impact when spoken into a microphone in front of an actual judge.
I think you're a human being and you're covered by the laws of the state of Washington.
A human being and a person are two different things.
No, I'm not interested in semantics. So
I'm trying to get down to the
you
facts,
can
man.
you can define things the way you want, but the law is not agreeing with you. All right, we're going to be back on September 20th, 1:30. We'll probably talk some more about your decision to represent yourself, and that's fine. But don't be surprised if whichever judge is there has another discussion with you about that. And at any time, you can ask the court to appoint an attorney. Anytime you can hire an attorney to represent you too. You're not prevented from that.
One attorney.
So we'll be back on September 20th, and you need to be back in court. If you're still in custody, we'll hear you in custody. And if you do post bond, you have an obligation to get into pretrial services within 48 hours and comply with them for sobriety monitoring. And that substance use monitoring program will pay for the Scram device.
Can we change the venue, ma'am, for lack of jurisdiction?
Well, you'll have to file all your motions in writing, and then you serve them as well on the prosecuting attorney, and then we'll set motion hearings.
I don't have the resources to do that in custody, ma'am.
I think you do.
I don't. There's not much paper here. There's no computers I can use, no printers. They're not giving me post stamps.
Offering you Thurston County Public Defense's assistance, I could.
Deny the right to defend myself. You want me to hire someone else to do it? I'm of sound mind.
I'm not denying that, and I'm not going to argue with you, sir. So, at any time, we can talk about standby counsel and talk about counsel.
Everyone represented. I will continue to proceed sui juris.
All right, that's up to you. All right, so we're done today, and those orders will be given to you in the jail.
All right, I don't consent to any of those orders.
And there it is. The judge brings the conversation out of fantasy land and back into reality. Notice what she focuses on. Not his philosophy, not his definitions, not the semantic debate about person versus human, but risk. Courts don't detain people because of language beliefs. They detain people because of danger and history. 2 DUIs, refusal, failure to appear, warrants. That's a pattern. The court has a responsibility not just to the defendant, but to everyone else using the road who didn't sign up to be hit by a drunk driver. This moment is key. He wanted to argue metaphysics. The judge is talking public safety. He wanted to debate vibrations and jurisdiction. The judge is looking at BAC levels, prior cases, and missed court dates. And when those worlds collide, only one matters in a courtroom, the one backed by statutes and precedent.
And folks, I'm guessing you're all here for the same case, since you're all sitting shoulder to shoulder. What case are you here for? Okay. And Ms. Moore, is Mr. Valentine, is that Mr. Valentine with you by chance?
Yes, it is.
This is Mr. Valentine,
Okay.
Your Honor, wishes to proceed without counsel.
Okay.
First of all,
Yeah, hold on. I'll let you know when I need to hear from you.
okay.
So Ms. Moore, has your office appointed somebody to replace Mr. Gaslin?
Your Honor, we were not appointed at the last hearing, and I'm not asking for appointment today as Mr. Valentine is declining representation. I have
Okay,
advised.
well, okay,
He wants
I'll take care of it. Thank you. Mr. Valentine, as Ms. Moore has indicated, you've told her you want to represent yourself. I'll tell you that's a huge mistake. I will treat you like you graduated from law school. I'm going to guess that because you're sitting there next to Ms. Moore, you have not graduated from law school, but you will be treated as if you had, which means I will expect you to know everything that I expect every lawyer to know. I will expect you to do the things that I expect every lawyer to do. I will expect you not to do any of the things that a lawyer is expected not to do. All that means that you haven't been trained in those areas, and yet I'm going to hold you to those standards. You would be making a bad mistake if you represent yourself, particularly because with 2 cases like this, you're probably looking at potentially up to 2 years in jail. So it's really important that you have good representation. If you were there, even if you had been trained as an attorney, I would say do not represent yourself. Lawyers know not to represent themselves. And there's a saying among lawyers that if you ever get charged with a crime, lawyers will say, it's a fool who represents himself. That is, even though they're trained to do that. So I would strongly recommend you not do that. You have the right to do it. I'll be very clear. I think you would be making a huge mistake should you do that. Do you have any questions about that? Do you have any questions about that?
Are you attempting to intimidate me under the color of law?
No. We're not doing anything like that. We're here on a pretrial. You have a confirmation hearing set for the 18th of October. Mr. Valentine, you have anything to say about that status? Otherwise, we're just going to close the hearing and move to that date.
I'm going over judicial notices that I've submitted to the court.
Okay. This is not a motion hearing. This is just a procedural hearing. And we'll just close out this procedure or this proceeding and confirm that your next court date is the 18th of October. If you wish to file a motion, you're going to have to do so in the appropriate fashion and get it before the court. It's one of those things that I've told you is why I advise you not to proceed representing yourself.
I have filed judicial notices with the court.
Okay, thank you. We'll set a motion hearing and have consideration of those. Thank you.
This is where sovereign logic fully jumps the rails. He's now arguing that being considered a person somehow means he is property or a corporate entity, and therefore not subject to regulation. In reality, person is a legal term used so laws can apply to, well, people. The judge answers him in the simplest way possible. You're a human, subject to Washington law. She refuses to go down the philosophical rabbit hole because that's exactly where sovereign arguments try to drag courts. Endless word games instead of actual legal issues. Here's the irony he misses completely. If he ever actually convinced the court he wasn't a legal person, he wouldn't suddenly become immune to law. He'd lose the very protections he keeps invoking. Non-persons don't have constitutional rights. They don't get due process, or jury trials, or appeals. So while he thinks he's unlocking a cheat code, he is actually arguing against the legal status that gives him rights in the first place.
Hi, folks. I don't want to hear any comments. None. So 18th of October is when he's due back.
And that's set for trial confirmation, Your Honor?
It's set for trial confirmation.
Thank you, Your Honor.
And Amy, if you'll make a note to...
I object to that. You're not allowing me.
We'll note your objection. Thank you.
We need to get you unmuted.
Yes, ma'am.
All right. So there are a couple of attorneys sitting behind you from Thurston County Public Defense. Did you want the court to appoint counsel or not?
No.
Were you going to hire your own attorney on the matter or represent yourself?
I've made it clear throughout all these proceedings that I'm proceeding sui juris.
Okay. I just need to always make sure of that. We've got confirmation set for the 8th. What is it today that you want to do?
I wanted to argue in some motions that I submitted to the court. A motion to dismiss, a judicial notices that I've dismissed about misconduct of the court and denied of access to the court. And I believe a motion to strike as well.
Motion to strike what?
It was a motion to strike. You guys had served a motion, no testimony to my house. I'm not sure what that was. The motion was never served to me, and the docket was never served to me either. It was mailed to my home. I'm not sure why, because the state was aware that I was in custody, but that's what my motion to strike was pertaining to.
Okay.
Your
Well, this is your motion today, and motion no testimony just means we didn't expect to see witnesses being called to the stand. So let me hear from the prosecutor here.
It's
Mr.
the state's
Weston?
understanding that the motion to request discovery and the motion to dismiss was heard on October 28th in front of, I believe, Judge Buckley, and he dismissed those motions. And the state's understanding is that the only motion that was going to be argued today was whether the court should grant funds for Mr. Valentine to hire an investigator.